Okay.
All right, we are almost done with the summary. We're going to start with license requirements, and I'm going to need a much louder, much more vibrant participation setting from you guys. But yes, we've put in, I don't know, 4.5 hours so far. So anyway, but listen, you must pass a test to get your license in the state of Missouri. Okay, and how long is the license? Everybody?
2 years.
2 years. And how much does it cost?
$100.
Look at that. It sounds like there's 50 people in the room. $100. Now listen, if you're a resident of another state and you have your license and you're in good standing, you can simply apply for the Missouri prepaid legal license exam because reciprocity exists between those states. Not every state falls into that category, but most states. If you are licensed in another state and you move here, you can transfer your license to Missouri. You have 90 days from the date you move here to do that. Otherwise, you are then considered a permanent resident of Missouri and you must take the exam. So do that within 90 days, please. Okay, if your license expires, you may renew it up to 12 months after expiration, but you're going to pay. How much do you pay?
$25 a month.
$25 a month. And if it goes past a year, everything starts over. You got to take the exam again, you got to do it all again. So, if you change your name or if you move, you have how many days to notify the director?
30 days.
30 days. And if you don't, you're going to pay a penalty each month of
$10.
$10. You guys have this down. So, your company will also notify the director of insurance if you are terminated for any reason, or if you leave, or if you're new, notice is going to be made. So when you leave, if you were terminated for reasons that are not going to be great, that it could result in an investigation done by the director of insurance. Because remember, they have ultimate power. They do what they want when they want. Okay, if a license is suspended or revoked, it will become public notice. An unlicensed person cannot receive any what?
Commissions.
Commissions. Perfect. No person shall solicit the sale of an insurance policy unless he or she is licensed to do so, or you're a licensed insurance company, its employee, or an insurance producer. Now, there is currently no continuing education required for prepaid legal. And there is no consideration for unlicensed person. That means they cannot receive commission. We discussed that earlier. But the term is no consideration, and that may or may not be on your test. But know that you cannot give any consideration or compensation to anyone that does not have a license. Now, solicitation of an insurance contract includes disseminating information as to rates. So if you're quoting rates and giving information about it, you are soliciting the sale of an insurance contract, and as such, you must be licensed. Good. Initiating sales over the telephone other than scheduling appointments. You must be licensed. But if someone calls someone that isn't licensed and says, I'd like to meet with Jason, when is Jason available? And they said, you can meet with Jason at 3 o'clock. Do they have to be licensed?
No.
No, because they're setting appointments. Advising an insured to purchase additional insurance when receiving payment for existing business. Okay, in other words, you cannot make a recommendation of any sort. There's all kinds of individual situations here. Signing an application for an order of insurance, advising a prospective purchaser on the terms of existing coverage. In order to do so, if you're a resident of this state, talking to residents of this state, you must be licensed. Any confusion on that?
No.
Okay, solicitation does not include scheduling appointments for a producer. We just talked about that. Receiving or recording information to be given to an insurance producer. Disseminating applications and forms, etc. Dispensing brochures and other general information. You cannot discuss the terms of an insurance contract, cost, etc. But you can provide pre-printed information in the course of assisting an insurance producer. Everybody got that?
Yeah.
Perfect. No one can negotiate or sell an insurance contract unless they are licensed or an authorized representative of a licensed person or entity. You can't advise or make a recommendation. And all business conducted online is the same as if you're doing it in person. The same rules, regulations, and requirements apply. Okay, suspension, revocation, or denial. You can read this, but I'm going to give you the gist of it. It may occur for one or more of the following reasons. If you lie about our product, misrepresent the terms, conditions, or facts of the policy, do anything unethical, commit a crime, you may not be able to get your license in the first place, and if you have one, you may not be able to keep it. Got it?
Got it.
Perfect. If a license is suspended or refused to be issued, notice must be given in writing and an appeal may be filed within how many days?
30 days.
30 days. Marketing practices. This is a lot of common sense stuff. Basically, you can't chase someone down at the scene of an accident and hand them a business card. You can't solicit outside of the courthouse. You cannot fail to offer services to someone that is protected under a certain class. You cannot force someone to purchase under duress. You cannot force someone to purchase or recommend something that isn't true based on their needs. In other words, you can't say, look, I think you need the business plan for up to 100 people when they have 3 people. Even though the business plan isn't covered under the test, that is misrepresentation. And it can result in you being not licensed. It can also result in you being prosecuted potentially because that's a license law violation. Everybody understand?
Yep.
Okay. Now, falsely advertising, you may not rebate, you can't pay for anybody's membership. Like everything, you cannot discriminate on the sale or offer to sell the service to anyone for any reason that violates a protected class. In other words, you can't refuse to sell, I apologize. Cancellation or non-renewal. There are a couple reasons why you can cancel or refuse to renew someone's policy. If they don't pay for it, that's pretty simple. If they misrepresent or they commit fraud as it relates to their application, you can refuse to issue. The named insurer or any occupant of the property has been convicted of a crime arising out of acts of increasing hazard against the insured. Okay, listen, basically what that means is if something they're doing can cause increasing harm to the company has a right to protect itself. Okay? Now, you may only choose to cancel or not renew based on legal, in other words, non-discriminatory reasons. All other definitions under marketing practices are also applicable. So when we go into definitions, I'm going to encourage you to be prepared for that as well. Notice of cancellation must be made in writing using at least United States Postal Service. Unfair claim settlement practices. Improper claims practices. Any of the following acts by an insurer, if committed, or if required but not committed. In other words, if they're supposed to do it and they don't do it, or if they're not supposed to do it and they do it, these are issues. It constitutes improper claims practice. You must acknowledge any claims, attempt to settle in a reasonable time, or provide just cause as to why a claim may not be settled. You got to make true and accurate statements. You cannot misrepresent anything. Upon completion of a claim or the investigation of a claim, you are required to take action immediately. Sometimes that's payment, sometimes that's physical action. Either way, you have to do it within a reasonable amount of time. In other words, it's our responsibility to act in good faith at all times and to provide service without variance to the insured. Also, you must promptly reply and communicate with the insured. Communicate any denial of coverage, communicate anything. Anytime communication is required, do so when planned or when required. Failure to do so is an unfair claim settlement practice. Got it?
Got it.
So what that basically means is do what you're supposed to do when you're supposed to do it, and there's never going to be an issue. Always realize that what you're doing is the same thing that the insurance company or the insurance director, the director of insurance, is requiring. Protect the public. Protect the director. That was loud. Protect the public, protect the director, protect the company, protect yourself. In that order. Okay, know your days. So let's talk about things that have to be done in 10 days. Okay. All persons or companies must provide documentation to the director to satisfy an examination of conduct within 10 days. Here's a hint. If you're in trouble, you probably got 10 days. The director must hold the content of the report, results of the investigation, before making it public. So if you're in trouble and they acknowledge you're in trouble, it's 10 days before everybody knows you were in trouble. So 10 days, you're in trouble probably. The number of days you have to pay a penalty prior to civil collection or action being brought. Voluntary forfeiture is included in that. The number of days to respond and acknowledge that you have received any claim. So are you picking up the theme?
Yep.
The theme is if you're in trouble, you got 10 days. So when in doubt, if you have to guess and you're in trouble, it's 10 days. 15 days. The director must notify the public of pending changes in any rules or regulations. They must provide forms necessary to present claims of a request with reasonable explanations regarding their use. Okay, so 15 days on important but not in trouble things. That was on the test? Okay. 20 days. Notice of a request for additional documentation. Okay, information or testimony to satisfy a complaint. So if you're already in trouble and you know you're in trouble and they just need to get you in a little more trouble, you got 20 days. Got it? So they've got 20 days to issue any kind of order. Okay? You guys laugh, but you're going to remember that. So 10 days, you're in trouble. 20 days, you know you're in trouble, and you just got to wait twice as long to find out how much more trouble you're in. So you're going to remember that, 10 and 20. 30 days. This is the time allowed for a company to dispute the results of a complaint or examination. It's done. 30 days, time allowed for the director to review a dispute. The company must file affidavits and notify the director that they have received notice of an adopted report or related order. If the results of that order are not disputed by the person named in the order, it becomes final in how many days?
30.
30 days. Okay, you must notify the director of a change of address. If someone joins Legal Shield or is terminated, how many days does Legal Shield have to let you know? 30 days. The director has to know, sorry. You must notify the director of legal action taken against the licensee. Okay, in other words, you have to respond and let them know that something's happened that they don't know about. So you're not in trouble with them yet, but you're about to be. So 30 days. Provide notice to an insured about cancellation or non-renewal of a policy. So here, basically any time that everything's out on the table, and you just need to make sure people are aware of it, you're going to get about 30 days to do that. I've changed my name. I got married. I got divorced. I'm already terminated from Legal Shield. I've got something going on and I'm just trying to see if I want to appeal or not. This is 30 days to do anything when everything's already out there. Got it? Okay, 60 days. The director must furnish written results of an examination of conduct or complaint inquiry. So this is when everything's already done. They've already investigated you. You're already done. You've already done your appeals. All that. 60 days, or I'm sorry, not done your appeals yet. 60 days for them to let you know just how much trouble you're in. So, got it?
Got it.
90 days. A non-resident moving to Missouri has 90 days to apply for a resident license without having to take the exam. 3 years. Keep all your records for 3 years. Keep records for any proceedings, paperwork, copies of policies, etc. Okay, and here's kind of the summary. The more serious, the quicker the results are needed. General rule, if you have to do it and you are not in trouble, you have 30 days. 20 days when it involves the results or documentations required from or for a special hearing. 10 days means you're in trouble and action is needed or the public is about to know. 15 days for any law change notifications. So, the director has 15 days to do most of the things that they do when they're not in trouble. We have 30 days to do it when we're not in trouble. Anything that's more pressing, it's amped up a little bit. So instead of having 30 days, 10 days. Instead of having 15, 10. So, and that is it. That is the entire summary. We had a couple things that we needed to add in there. And no, we'll do that in tips. So, you're going to be really editing this a lot, Jason. So I will tell you, if you're seeing this version and you're seeing all this, we're going to put the raw footage up first so that people have it so they can access it probably. But the finished product will be nice and pretty. But there's definitions in here. I encourage you to go through and understand the definitions. And you are pretty much finished with the summary. Prior to taking the exam, I encourage you to take the practice test that we have online. And the practice test is going to be set up where you can go through and get your answers to, I think there's about 120, 130 simulated questions on the test that you can go through and just kind of test your knowledge. And also take a look at the tips from people that have already taken the test. And there's going to be a subsequent video called Tips and Recommendations. So, you got questions?
Not a question, I just wanted to share some good news with you. I just got a text from my son Glenn. He just passed the test.
All right.
Yeah, we had somebody pass the test. And I wasn't even involved in any way, so I can't take any credit for that. But, all right, so I'm going to cut, and then